Okay, let's go. Welcome to the plenary session on, quote, NSA surveillance and its consequences. The theme fits nicely into the larger theme of the convention entitled After the Digital Revolution. Controversies surrounding the NSA deeply implicate the uses and potential abuses of digital technology by government and non-governmental actors. Violent jihadists use digital technology to build their movements, and states use it to trace these threats. As legal and national security scholar Philip Bobbitt has said, terrorist movements often reflect or mirror the resources, tools, and aspects of the societies that they attack. They use digital technology to attack us, to build their movements, and we use it to track them. In a sense, according to Bobbitt, we feed the very forces that we're fighting. So digital technology has provided great benefits, yet also enhanced threats. Many say this paradox also applies to the NSA. It too uses technology, digital technology, to protect us from terrorism, but there's also the potential for abuse. I'm reminded of James Madison's famous statement in Federalist 51, where he said that we need government to protect us, but at the same time, we need what he called precautionary or auxiliary precautions to protect us from the government. If indeed there are angels, they don't dwell on this particular earth. Now, we're fortunate enough today to have a very distinguished panel to discuss the NSA and to set the stage for what I hope will be a very interesting Q&A. I am Donald Downs, University of Wisconsin, and I'm the moderator of this discussion. It's also, especially given the situation in the world today, what's going on in Iraq and in Syria and elsewhere, the discussion is all the more relevant. Now, that said, to get a grasp on the NSA and what it does is difficult. For one thing, the government has modified the programs repeatedly in recent years due to judicial, political, and public pressure. And adding to the fog is the classified nature of the NSA's work and the complexity of its interactions with the NSA, with the FISA courts, Congress, and the executive branch. In addressing the NSA question, we have to know enough trees, know what's going on, but also see the forest. And I hope that the panel today will get the right balance. And if the NSA is watching this plenary session, welcome. If Germany's watching, welcome to you too. Now, let me give you a sampling of the questions we'll be dealing with. How legal are NSA's programs? How effective are they? Indeed, what are they? How serious are the dangers and threats that NSA programs address? And how do we define these dangers for legal and policy purposes? Is there a way to obtain sufficient data without sweeping communications and information into metadata and other forms of data collection? Or is such sweeping necessary? If so, what are the safeguards? How much should the rules and norms governing foreign intelligence gathering differ from the rules and norms governing domestic law enforcement? Just how different is foreign intelligence gathering from domestic law enforcement? How much overview is provided by the system of checks and balances in our constitutional system, such as judicial review, congressional checking, public opinion, the press, inspector generals, the executive branch oversight, and have such checks been sufficient? The NSA has often done its job with secrecy, especially in the past. So, what is the proper balance between secrecy and openness in a constitutional democracy, and who should decide where that line is drawn? What is the role and legitimacy of whistleblowers and leakers in our system? What is the legal and normative status of Edward Snowden, whose leaks provided so much information, especially about the metadata programs? What about other leakers and whistleblowers? If Snowden returns to America, should he be punished? Or is spending a few years with Putin punishment enough? How has the simple growth of new technology been responsible for the nature of NSA programs? How does the press deal with the publication of stories involving national security? How do public opinion and the press shape policy and the government response? And finally, what is the classic trade-off between liberty and security? Or as Benjamin Wittes has said, there really is no necessary conflict unless we become unbalanced on one side or the other. That security and liberty actually should reinforce one another if properly done. Now, before I introduce the panel, I want to say something very briefly about the programs to sort of set the stage, and the panelists will say a lot more about them. The NSA was officially established in 1952, though it was based on previous intelligence operations. The core mission, as I've said, is to gather foreign intelligence through surveillance. And this mission is distinct from the normal operations of domestic law enforcement. Indeed, when the Foreign Intelligence Surveillance Act was passed in 1978, itself based on a reaction to previous abuses of surveillance by the government, its main objective was to give the government the power to do what's necessary when it comes to foreign surveillance, at the same time preventing that power from leaking over into the domestic sphere. American citizens are distinct from foreign intelligence dangers. Of course, what happens when there's a third category, when American citizens are involved with foreign intelligence? And that's sort of that third area where a lot of controversy arises. Much of the controversy over the NSA programs in recent times pivots around this congenital concern, as non-foreign intelligence has often been swept into the intelligence gathered regarding foreign intelligence. Now, since 9/11, for the most part, and this is sort of my father's Sarducci reduction of the programs to a simple formula, there are four basic programs that have been used. Two of them are content-based surveillance of telephone and internet communications. Section 702 of the FISA Act amendments, 2008, addresses when the NSA may look into this content. If it's purely foreign intelligence, it lies beyond the purview of the Fourth Amendment. But if it's intelligence that pertains to American citizens, then there are legal standards, and such investigation needs to be covered by the law. The second set of programs involve metadata collection, both internet and telephone. Now, it's my understanding, maybe the panel will correct me, that the internet program has been dropped or seriously modified, but the telephone program remains. This is largely covered by Section 215 of the Patriot Act, the business records provision. Metadata has been stored by government and private communications providers. It includes such things as numbers dialed, time and length of the calls, the ID of cell phones, cell phone information, websites visited, and the like. This data does not itself pertain to the actual content of those communications. And at one time, the Supreme Court held that such information is not covered by the Fourth Amendment because it's been given out in the public and it does not deal with content. But those decisions occurred many decades ago when technology was not nearly as developed as it is now. So there's a greater concern with the new technology. In order to get into the content of this, a FISA court authorization is required. And there's a big debate, and our first speaker will address this, as to whether or not prior authorization is required to even look at the metadata itself, independent of the content. Now, the communications content provisions were ultimately approved by the FISA court after the New York Times leaked this or published information about them in the mid-2000s. Meanwhile, the extent of the metadata programs is not really known until Edward Snowden in early 2013. After the FISA Amendment Act of 2008, all four programs were given legal cover. But we now know that the FISA court and the NSA have been involved in a lot of back and forth in recent years over compliance. Some say this tension shows the FISA courts are doing their job. Others say it shows that they haven't been sufficient guardians of our civil liberties. In the wake of Snowden's disclosures, the government in recent months has discussed 3 different reform proposals. I won't get into those now for reasons of time, but I assume that the panel will be talking about them. And it'll be interesting to see whether or not they go forth given recent events in the Middle East. Remember back in 2009, we had the Christmas underwear bomber over Detroit. Reforms were in the making apparently back then, but as soon as that act took place, reforms were stopped. So there seems to be kind of a pendulum effect given the immediacy of terror threats and the strength of proposals for reform. Let me turn now to the panel. It's a very distinguished group. I'll present them in the order that they will present their initial comments. First is Professor Laura Donahue, Georgetown University Law School professor. She's written extensively on the NSA and related matters, including 2 recent extensive pieces, which I had the pleasure to read before the conference. She's advised leading privacy groups and assisted in legal litigation. Professor Donahue will talk about the legal implications of mainly the bulk metadata program, but she'll probably also allude to Section 702. Seem to be 2 sides of the same coin in many respects, in my view. Second speaker will be Matthew Olsen. Mr. Olsen is now the director of the National Counterterrorism Center in Washington. And before that, he served as general counsel for the National Security Agency, where he held the position of chief legal counsel. He also served the Department of Justice as an associate deputy attorney general and was responsible for supervising and coordinating national security and criminal matters. Mr. Olsen has also had the honor of serving both the Obama administration and the Bush II administration. He will talk about the nature of terrorism, the threat it presents, and what the NSA is doing to collect intelligence to support our counterterrorism efforts. He'll also focus on the surveillance and the role of the NSA programs, the role they play in our ability to identify and disrupt terrorist threats. Third speaker will be Martin Barron, Executive Director of the Washington Post. Before that time, he was the editor of the Boston Globe, the executive editor of the Miami Herald, and associate managing editor of the New York Times. A piece I encountered online asked, is Marty Barron the man to fix the Washington Post? I assume that he is, but I know for sure he'll contribute to our panel. He will talk about the press and how the press deals with reporting sensitive national security stories and how it interacts and negotiates with the government regarding such stories. Perhaps Martin and Matt have engaged in such interactions in the past, though they recently told me that it had not really done so. Peter Feaver is a professor, who will be our last speaker, of political science at Duke, where he's widely known for his work in international relations, national security, peace, and conflict studies. He's the director of the well-known Triangle Institute for Security Studies. He's also the director of the Duke program in America, in American Grand Strategy. From June 2005 to July 2007, Feaver was on leave to be the special advisor for strategic planning and institutional reform on national security with the National Security Council staff at the White House, where his responsibilities included national security strategy, regional strategy reviews, and other political military issues. He's written widely on such matters as national security, civil-military relations, and the costs of war. His remarks will focus on the larger political and public opinion dynamics in play in this issue area and how these dynamics impinge on policymakers' calculations. So our format's the following. Each panelist will present, we said 5 minutes, but they may bleed over their particular matters. And then we'll have an exchange where they'll reply to one another. And after that, we'll open up to Q&A from the audience. So without further ado, why don't we start with Laura Donahue.
Thank you very much. Are the microphones working? Okay, good. We've decided to discuss from the table today. So first, I'd like to thank Don for the introduction. It's a wonderful opportunity to come together to discuss these issues, and I'd like to thank my fellow panelists in advance. I'm looking forward to the discussion. As Don mentioned, there are two central programs that have really captured attention. The first is the bulk collection, Section 215 matters, and the second is Section 702. So in light of our limited time today, I'm going to really focus on Section 215. What I'll say up front about 702 is primarily my primary concerns constitutionally with how 702 is being exercised relate to the post-targeting analysis and the use of foreign intelligence information in ordinary criminal prosecution without any of the protections one would otherwise see in a Fourth Amendment context. And I'd be happy to return to that during the discussion. Don also mentioned that there are two articles. There's a two-part series in the Harvard Journal of Law and Public Policy. The first one was just published. The second one will be published in a couple of months. And these deal with Section 215 and 702. So as far as the forest goes, at 160 pages each, they're pretty much in the forest. So feel free, if you want to take a look or if you have questions, comments, critiques, I welcome all of that on the articles as well. So let's focus on Section 215. What I'd like to say is three things about Section 215, and particularly bulk collection under 215. First is it violates the whole purpose of the Foreign Intelligence Surveillance Act. Second, that it's illegal under the statutory language passed by Congress. And third, that it's unconstitutional. So as you can see, I don't have a view on bulk.
Other than that.
Other than that, it's great.
Okay.
Yeah, other than that, NSA top marks, right? And here's why. Let me explain. So first, it violates the purpose of FISA. In the 1960s and 1970s, there were a plethora of programs that all of us in this room know well that had to do with the collection of bulk information on U.S. citizens. The NSA, for instance, in a program called Project Minaret, collected information on a total, by the way, of 1,650 people, no more than 800 people at a time. In Operation Shamrock, they intercepted all international communications and scanned about 150 cable messages per month looking for ties for foreign intelligence. Now, one characteristic of these programs is they started limited. So Operation or Project Minaret, for instance, started by only monitoring Americans traveling to Cuba, but they quickly expanded to include anybody involved in civil disturbances, criminal activity, suspected drug activity, individuals of interest to presidential protection, individuals suspected of international terrorism, and so on. And this spurred Congress, and the Church Committee in particular really led the charge here, to say that they did not want to create opportunities for executive branch agencies to collect bulk information on U.S. citizens. That was the purpose behind FISA. They were also concerned that developments in technology would allow agencies to exploit ambiguities in the law to intrude upon American citizens' privacy. These are the stated aims in Congress of this legislation. So to protect U.S. persons, not just from NSA surveillance, but also from FBI programs like COINTELPRO or the U.S. Army's Operation CONUS or the IRS programs, all of these, FISA established four important protections for U.S. persons. First, any information from electronic intercepts in particular had to be specifically tied to an individual. Right? You could not just collect all electronic intercepts. Second, that individual had to be identified as a foreign power or an agent of a foreign power prior to collection of information on that person. Minimization procedures had to be put into place, and the Foreign Intelligence Surveillance Court would oversee this process. Now, initially, FISA dealt with electronic intercepts. It gradually expanded to include four areas: electronic intercepts, physical surveillance, pen, register, and trap and trace, and that's really what's at issue in the telephony metadata programs. That is the numbers one dials from one's phones and the numbers one receives on one's phone. That's PRTT, pen, register, trap, and trace. And finally, business records and tangible goods, which also is of issue because this is the provision under which bulk collection takes place. Now, in regard to what has happened under Section 215, many of these basic principles and the approach of Congress and the purpose of introducing FISA have really been countered by NSA's actions. First, there's no particularization prior to collection. The orders that are issued by Verizon or to Verizon just are bulk collection. There's no prior targeting, so there's no probable cause that the individual was involved in any sort of criminal or foreign intelligence-related activity. Before, they had to know the target to get information. The argument is that now they get the information in order to ascertain who the targets are. It's completely backwards from the approach that FISA traditionally has had. Third, there is not a higher threshold for U.S. persons for the collection of information, and that's counter to the purpose of Congress in FISA. And the role of FISC is shifting. We're seeing a different role where FISC opinions are being offered as precedent, not simply as monitoring whether or not probable cause standards have been met prior to targeting of U.S. persons for foreign intelligence collection. Okay, so that's the first argument, is that this is really contrary to the principles of FISA. The second point I'd like to make is that it also violates the statutory language itself. And there are, in this regard, three ways in which it does so. The first one I want to focus on is the actual language, which says that the government must have reasonable grounds to believe that the tangible things sought are relevant to an authorized investigation other than a threat assessment. And this is 50 U.S.C. 1861 for the statutory provision. So again, there have to be reasonable grounds to believe that the information, that the tangible things sought, are relevant to an authorized investigation other than a threat assessment. So what's happening in this regard is the government argues that all telephony metadata is relevant to authorized investigations. Okay, all telephony metadata is relevant to this. But that makes the phrase relevant to completely meaningless. So if all telephony metadata is relevant, then what is irrelevant to an authorized investigation? It also makes the reasonable grounds provision in that statement. You must have reasonable grounds to believe that this is that all records are relevant to an authorized investigation. It makes the prior clause, it reads it out of existence as a statutory matter. It also establishes a very concerning precedent. So if all telephony metadata is relevant, then so is all email metadata, all internet metadata. All financial records are relevant, all communications, all social media. You could go on and on. All of this would be relevant to assessing a potential threat to the United States. So what is irrelevant? And this very clearly contradicts congressional intent. Now, an authorized investigation is also part of that phrase. And the way that it's being read by the NSA treats the search of the data, not the collection, as the part that must be relevant to an authorized investigation. But the statute requires that the information to be obtained must be relevant to an authorized investigation. An authorized investigation, under the Attorney General guidelines, requires a level of specificity prior to collecting information, whereas bulk collection does not in this regard. In addition, the orders issued by FISC allow for the future collection of information. So the investigation might not have been yet authorized, and you are now granting the authority to obtain information without that investigation actually being in existence. But the statute is very clear that it has to have already been established. So that's the first set of ways in which the statutory language is violated. The second set of ways relates to subpoena ducis tecum. So the statute requires that the NSA, that the type of information, not just NSA, but anybody using Section 215, that information must be could be obtained under ordinary subpoena ducis tecum. It's pretty clear that you cannot use subpoenas for fishing expeditions. So I couldn't convene a grand jury in Bethesda and just see what's going on in the city. You know, I couldn't just start collecting telephony metadata to see potential criminal activity. That type of use of subpoenas has been roundly rejected by the Supreme Court. In addition, subpoenas must be focused on individuals, particular individuals, and they're related to particular crimes. They're not just a search for information of potential criminal activity or of potential criminals who might be of interest. And there is an emphasis with subpoenas on past wrongdoing, on things that have happened or current wrongdoing and specific crimes that have occurred. The third statutory argument to consider with regard to the bulk collection is pen register and trap and trace. So FISA actually has extensive provisions for pen register and trap and trace information, so numbers called and numbers received on one's phone. reading Section 215 the way it does, the government has done an end run around the pen, register, and trap and trace provisions, that statutory language, where Congress clearly limits and restricts and sets out guidelines for how that information can be collected. Okay, so on to the third final set of arguments, which is the constitutionality of this. In my view, this is unconstitutional, and this is why. So the government relies, in this case, on the case that Don referenced. This is a case called Smith v. Maryland in 1979. This is a case, a local case, actually, for us here in D.C. Up in Baltimore, Maryland, a woman named Patricia McDonough was robbed, actually, and at the scene of the crime, she saw a 1975 Monte Carlo car, and she told the police she saw the car, she had been robbed. She went home, and somebody called her on her home phone. He basically had stolen her purse, and he called her on the home phone, identified himself as a person who had robbed her, and told her to go out on her porch and made a number of threatening remarks to her. She went out on her porch, and a 1975 Monte Carlo drove very slowly by her house. So he was trying to intimidate her and harass her. She called the police, and the police saw a 1975 Monte Carlo in her neighborhood. So they took a look at the car, and they said, from the license plate, they figured out who owned the car, and they went to the telephone company and said, may we place a pen register on the telephone line? Now, at that time, there was no ability of telephone companies to actually record the numbers dialed from a phone or received by a phone. At that time, local calls were billed in minutes. So it was because the police had this special device and gave it to the phone company that they could do this. And when the case, when they placed the pen register on the phone, the next morning, Michael Lee Smith called her on the telephone. They used this information to get a warrant, went into his house, and there's a phone book turned down, dog-eared, to her telephone number in the phone book, right? And they use this evidence in trial against him. So the Supreme Court says that Michael Lee Smith had no privacy interest for purposes of the Fourth Amendment in the numbers he dialed from his phone because it was out of his control. It was in the telephone company's purview. And that gave birth or rise to what is known as third-party doctrine in the law. So the government looks to this and says, look, the telephony metadata we're collecting is third-party data. We're just recording this information that the telephone company has, which includes not just numbers dialed and numbers received, but also trunk identifier information, which places your location within a reasonable boundaries. And this information has been collected 24/7, 60/60 for years. Okay, so what is wrong with the reliance on this case? Well, privacy interests implicated by current technologies are significantly different than the privacy interests that were implicated in 1979. There are tens of millions, hundreds of millions of people potentially impacted by these orders. Their location information and the ubiquitous nature of the surveillance and long-term nature make this qualitatively different than what happened in 1979. Now, the court has recently decided a number of cases under both Katz and trespass doctrine. And I would suggest that under either approach, whether one adopts Justice Scalia's traditional originalist trespass approach or whether one goes to the higher bar of Katz, that under either approach, this is unconstitutional to simply collect bulk records on American citizens. On the trespass side, this is a general warrant. This is exactly what gave birth in many ways to the Revolution. General warrants were used at the time of the founding. Remember, Entick versus Carrington in England was seen as protecting the rights of Englishmen against general warrants, but William Pitt, Prime Minister, directed the governors in the American colonies to use general warrants to go into people's homes and look for evidence of possible criminal activity. And James Otis was the one who famously argued in Paxton's case that this was the worst instrument of arbitrary power, he said, the use of general warrants. John Adams, who was actually at the argument, later said, then and there the child liberty was born. This was seen as the first shot in the Revolution back to England, saying we will not accept general warrants. So the Virginia Declaration of Rights actually included a prohibition on general warrants. Virginia and New York and a number of states, as a condition of signing the U.S. Constitution, said there must be a prohibition on general warrants, and that is what the Fourth Amendment came to embody. That is what Madison said. This is to protect against general warrants. So giving the government the ability to collect all telephony metadata without any evidence of criminal wrongdoing, that looks a lot like a general warrant and as a digital trespass on the private lives of American citizens. But one can also go to cats, right? Now, Justice Scalia, in a recent case, Jones, he said, one cannot read the Fourth Amendment to read rights out of existence at the time of the founding, so we can look at general warrants in this context. But there is as well an approach to this through cats. There was a recent case, U.S. v. Jones, where a GPS chip was placed on a car outside of the warrant, the 10 days that had been required by warrant, and outside of Washington, D.C. It was on a drug dealer's wife's, suspected drug dealer's wife's car. And the court said in that case, they decided the case on trespass, Justice Scalia writing the opinion for the court, but there were 5 justices who came out and said that under cats, one has to take account of the reasonable expectation of privacy, and that technology is changing this picture. That technology is changing what these things look like, particularly Justices Alito and Justice Sotomayor. They took on board this point directly and said this is something different. Justice Sotomayor went so far as to say she would overturn third-party doctrine in light of the intrusive nature of these technologies. Now, there are a number of cases one could point to. I'm going to wrap it up now because I know we're on limited time, but there's a case Kylo, which deals with thermal imaging. In 2010, we have U.S. v. Warshak, which is a Sixth Circuit case looking at the reasonable expectation of privacy in email. We have Cotterman, which is a Ninth Circuit case looking at personal information in digital form. We have Jardines, where Justice Kagan looks at cats and reasonable expectation. We have this growing, Ganius being one of the most recent ones, this growing body of case law where the court is starting to recognize and say, wait a minute, there is a privacy interest in this digital information, and this is a heightened interest in something different than what we have previously seen. So just to recap, Section 702, my primary concern there has to do with post-targeting analysis and use of the information for criminal activity. For 215, I see it as contradictory to Congress's purpose in introducing FISA, as violating the statutory language, and as unconstitutional. Thanks.
All right, well, I'm going to follow Laura. It's not going to be easy, is it, for me as the NSA General Counsel to follow Laura and her. She's done a lot of very extensive and interesting work on this. Let me say that I'm here in some ways more in my current role as the director of the National Counterterrorism Center, and I'm going to sort of stay in that lane for a bit, although I'll talk a little bit about the law at some point. But I'm probably here primarily, actually, because my daughter is now a junior at the University of Wisconsin and took Professor Downs' class. And last year, I had the privilege of speaking to Professor Downs' class with my daughter in it about national security and the First Amendment. So as I look out at you all, I'm hoping that you guys actually are easier than that group was on my arguments. They had a lot of good questions. But so I'm going to stay in the forest and not the trees for a moment, and I know we'll get down into the trees, and I look forward to having that discussion. But so, I look at this now, NSA surveillance, from an operational perspective in my current role. And the National Counterterrorism Center is essentially a clearinghouse, post 9/11 creation, clearinghouse for analysis of terrorism information. Yes, the subject of today's talk is NSA surveillance and its consequences, and I do have a particular perspective now on the consequences of that surveillance. My view is that surveillance is absolutely indispensable to protecting the country. It's our daily bread. Every day I get a threat briefing. I had one this morning. It lasts about an hour, where we go around the world, find out what's happening from a terrorism perspective. And one of the primary, if not the primary source of information about terrorism comes from the collection of information that NSA carries out around the world. It's really through these reports, NSA reports, that we have the opportunity to see the actual communications of the people who are targeted, the targeted terrorists that are seeking to carry out attacks against our interests around the world as well as here at home. So I approach these questions right now, as I said, from a particularly operational perspective. Obviously, I understand that there's a lot more to it than just the operational side, and Laura's remarks make that clear. But let me make a few preliminary comments, let me devote my preliminary comments to the nature of the threat, because as we have this conversation about striking the balance, as Professor Downs referred to Ben Wittes's comment about when that balance gets out of whack is when you have a problem. So I think you need to understand, in thinking about that balance, okay, what's the nature of the threat? What's the nature of the adversary that we're trying to learn more about to protect the country? And I'll talk about that, and then I'll talk about how NSA surveillance fits into that, and then I'll touch on, third, very briefly, the impact of the disclosure of the stolen documents and how that's affected our capabilities. So the short answer on the threat is that it's increasingly complicated, and it's persistent, and it's diverse, and it's geographically diffuse. It's changed a lot in the last 10 years. It's much different from what we faced right after 9/11 and the years shortly thereafter, where we really were talking about a monolithic threat coming out of the Afghanistan-Pakistan area. Basically, al-Qaeda and al-Qaeda senior leaders who had established a safe haven there. We now are talking about a diverse range of actors, not just core al-Qaeda in Pakistan, but a number of groups and individuals who have varying degrees of affiliation with al-Qaeda. And it's, you know, as Professor Downs said, you can't not see this today when you turn on CNN or open a newspaper. You have groups that are officially affiliated with al-Qaeda, like al-Qaeda in the Arabian Peninsula, the group that was responsible for the Christmas Day 2009 effort to take down a plane over Detroit. You have al-Shabaab in Somalia, that's an official affiliate. Al-Nusra in Syria, official affiliate of al-Qaeda. You have groups that are aligned with or even have splintered away from al-Qaeda. So aligned groups like Boko Haram in Nigeria. ISIL or ISIS, the group that's primarily in the news right now. That's a group that's splintered off from al-Qaeda. It used to be al-Qaeda in Iraq. And beyond that, you have a number of individuals in places like Libya, Egypt, who have varying degrees of adherence to the ideology. You have people here in the United States who adhere to the ideology of al-Qaeda. So the way that the threat picture looks now is much more diverse, much more fragmented than it was 10 or really even 4 years ago. Beyond that diversity, you have a geographic diffusion. So, as I mentioned initially, it's not just centered in the AFPAC region. This threat now spans a wide geographic area, going from South Asia, Pakistan, and Afghanistan to the Middle East, to the Levant, and across North Africa, all the way from in the east, Egypt, to Mali and Mauritania in the west. So this geographic diversity or geographic diffusion also presents a real challenge for us from a terrorism perspective. And then the third feature of the threat is that it's proven to be quite adaptive. So where we were concerned 10, even 5 years ago about centrally planned plotting from al-Qaeda senior leaders in Pakistan, we're now increasingly concerned about the change in tactics, where they're looking to carry out smaller scale, less sophisticated attacks, but attacks that don't require any central planning, don't require people to travel or communicate directly with central planners or leaders in some of these locations. So they've changed their tactics. They've also changed their tactics in how they communicate, understanding that that's a vulnerability for them. So we have a threat that is increasingly diverse, geographically diffuse, and adaptive. So the question then is, the second thing I wanted to mention along these lines then is, why is NSA so important? Why is it important for us to be able to collect communications? And the reason flows directly from the nature of the threat. It's very difficult to infiltrate these groups. They are inherently suspicious. They kill people who they suspect are spies. One of our primary ways, then, of being able to understand their intentions, identify individuals who belong to these groups, perceive the plotting that's taking place, is to be able to get access to their communications. It's also the case that with the geographic spread of this threat, that our ability to have sources, human sources, is limited because we can't get to all of these different places. It's another reason why NSA surveillance and collection is so critical. A third is just the inherent reliability of this type of intelligence. So it's really the gold standard, right? We're not relying on someone to report on what they hear, where they may have inherent bias or or limitations on what they have access to. We are actually able to get the communications of the individuals we're seeking to learn more about. So we're getting their actual emails or telephone calls. And all of this really goes to the point, the fundamental point that I started with of NSA surveillance as a general proposition is absolutely indispensable to our ability to counter the threat that we're seeing and that's continuing to proliferate. A couple cases in point. Syria. So obviously the news, we're seized with what's happening in Syria and Iraq. In Syria we have the unrest has led to really a magnet for foreign fighters. So we have over 12,000 foreign fighters going to Syria. That number is going up all the time. More than 1,000 of those coming from Europe and more than 100 coming from the United States. Going to Syria to join the opposition, and many of them joining the extremist groups like al-Nusra, an al-Qaeda affiliate, as well as ISIL. Our concern is that as these individuals go to these places, they are eventually going to get trained, further radicalized, and return home. One of our great challenges right now from an intelligence perspective is identifying these individuals, understanding what their intentions are, and if they are involved in plotting, being able to disrupt that. That's why that's a very good example of where the types of intelligence we get from NSA is critical to our ability to understand this emerging threat. Another point or example I wanted to share, because it goes directly to what Laura talked about in terms of the particular programs that I know folks are interested in talking more about, Section 702 and 215. And I know we'll talk more about the legality of those because I have something more to say about that. But the specific example that's been more widely discussed and many of you may be familiar with is Najibullah Zazi. So Najibullah Zazi was an individual in Aurora, Colorado. In 2009, NSA, using Section 702, was targeting an individual in Pakistan who was connected to al-Qaeda. And by targeting that individual in Pakistan, they intercepted an email between the individual in Pakistan and this individual they didn't know anything about. Turns out his name was Najibullah Zazi, living in Aurora, Colorado, in which they were sharing information about how to prepare an explosive device, a recipe for an explosive device. Because of that intercept, because of that collection, NSA identified this individual in Colorado, shared that information with the FBI. The FBI initiated an investigation of Zazi. Zazi eventually, he was days away from traveling to New York. Eventually, he was arrested by the FBI as he was on his way to blow up the New York subway. In addition to identifying Zazi, the NSA used, and FBI used Section 215 to corroborate the identity of an accomplice of Zazi by looking at the phone records for this individual. The Attorney General called this one of the most serious threats we've faced since 9/11. It was a plot that was real, it wasn't aspirational, and it was stopped because of NSA and because of these programs. So the third thing I want to say is, and I'll talk just for a moment about this and turn it over to Marty, is a word about the impact of the disclosures. The bottom line is the documents that were stolen from NSA and then disclosed have had an extremely damaging impact on our ability to collect information. We've lost the ability to intercept the communications of key terrorist operatives and leaders. Look, we know these groups monitor the press. We know they're suspicious of our ability to collect their communications. It's not news to them that the NSA and the United States government, intelligence agencies around the world are trying to collect their communications. But what this information did was essentially confirmed in excruciating detail the scale and scope of our capabilities. And in many ways, it revealed information that had nothing to do with the privacy or civil liberties of Americans. It was purely information about the capabilities, the technical capabilities of U.S. intelligence agencies. We have specific examples of terrorists who have adopted greater security measures in the last year, including various types of encryption. They've changed internet service providers. They've dropped or changed email addresses, and they have otherwise, in some cases, just ceased communicating in ways they had before and dropped out of our ability to see what they were doing. So again, an extremely damaging impact on our ability to collect these communications. So look, we're at a point now, though, where we're dealing with this, and the president has made significant changes, for example, in the 215 program. So it no longer looks like what Laura described. But we have a lot of work to do to address the erosion of trust that's been created, and I think that's something that is part of why it's important to have discussions like this with informed and influential audiences like you all, and why I welcome the opportunity to have this discussion. So thanks.
Great. Well, thank you, Matt. So what I'll try to talk about here is how and why we decided to publish, how we went about our work, and how we think about national security issues in our coverage. I'm not a lawyer. I'm not going to pretend to be one here or play one here, so I may be at some disadvantage, but I think I can speak at least in broad strokes about the role that we see for ourselves in coverage of this nature. National security, as you might expect, is an area of intense focus for us at the Washington Post. I don't think that should be a surprise. It's one of the greatest powers of government. That's the power to make war, to spy on people, to interrogate people, to prosecute, to incarcerate, and kill. All of those are the greatest powers of all, and they are vested in our government as they are in every government around the world. We have to cover the federal government. And in covering the federal government, those are not activities that we would choose to ignore. And nor are those activities that, in my view, we can simply defer to the government's wishes on what we should report, how we should report it, what not to report, whenever the government asserts a national security rationale, or whenever the basis for our coverage is classified material. The government has shown a remarkable, maybe not so remarkable, addiction to classifying documents of every sort. An enormous amount of information now is classified, including a lot of information that is relatively innocuous. There can always be a rationale for keeping something classified. And as a result, very sweeping government policies with profound implications for individual rights. The Fourth Amendment we've talked about here, the First Amendment as well. Those have been put into place in secret. You know, the Constitution of the United States begins with the phrase, "We the people," and it presupposes that the people will be involved in self-governance, that this will be a government of, by, and for the people. And the premise of that is that the people actually have information about what their government is doing, that they have knowledge of that. So our purpose is to try to provide that information so that we can actually have self-governance in fact and not just in name. At the Post, we have a highly experienced national security staff. I think the people on this panel are aware of that. They have a lot of interactions with the people on our staff. We do rely on their expertise and their history of navigating the most sensitive subjects imaginable. We recognize that there is a tension between between self-governance in this country and national self-preservation and self-protection. There's no question about that. And we are not dismissive of national security concerns. We do take them very seriously. We recognize that it's a dangerous world, as we've heard already. We certainly know that. And nor do we doubt that the government needs to engage in intelligence activities and surveillance as well. So this is not an issue of whether we should have intelligence activities or no intelligence activities, or whether there should be no surveillance whatsoever. So as a result of that, our reporters communicate quite regularly with the Pentagon, the White House, the intelligence agencies. On the NSA documents that are at issue here, we spent many hours on each story in detailed conversations with high-level officials. I think there was one occasion where there were 16 officials with our 1 or 2 reporters from pretty much every agency in government at the time. And then on many occasions, at the request of the government, we have withheld information that might disclose very specific sources and methods. And in withholding that information, we ourselves have come in for criticism from a certain segment of the population that we were denying the public information that it was entitled to have. However, we did not agree and would not agree to every request of every sort made by the government. Had we done so, we would have had no stories whatsoever, because the intelligence agencies obviously would have preferred that we not publish a single word on this subject at all. You know, the Director of National Intelligence and a leading congressman have said that, I think chillingly, that the journalists who revealed this information, these contents of these classified documents, were the accomplices of Snowden. That was the phrase that was used. And one congressman has suggested that we should have been prosecuted under the Espionage Act instead of being awarded the Pulitzer Prize for public service. Thankfully, I'm here, able to attend this panel and be in front of all of you. I think what we saw in the documents that we received from Snowden was something that went beyond the specific sources and methods that the press had traditionally guarded on grounds of national security. The documents had revealed that the NSA was engaging in surveillance of, I think, breathtaking scope and breathtaking intrusiveness to a degree that many in the public could never have imagined and certainly would never have approved. What we had here, we believe, was a national policy, not just sources and methods, and a policy that had dramatically shifted the balance toward state power and shifted the balance away from individual rights, including privacy. There had been no public knowledge, there had been no public debate, and knowledge within the government itself was sharply limited. So now we have that debate. We're able to have panels like this and discuss what is appropriate policy. And knowledge is not just limited to a select group of powerful individuals within the government who are shielded from oversight by the people they represent. And I'll turn it over.
Thank you, Marty. So it's an honor to be on a panel like this, even though I realize my presence diminishes the average luster of the panel and perhaps the average salary as well. I'm just hoping my dean sees this on C-SPAN and takes steps to rebalance that last piece of it. I'm going to speak 5 propositions about a group referenced in Martin's remarks, namely we the people. What's the broader political and public opinion context for this issue? And I'm going to make 5 propositions. The first proposition is that the public is not nearly as Ron Paulish on this issue as the Washington Post or New York Times coverage might make you think it is. By Ron Paulish, I mean tired of war, wanting to retrench at home, and fearful that the government is a bigger threat to their freedom than terrorists are. And I just commend to your attention a forthcoming Chicago Council poll that surveyed the public on a wide range of foreign policy, national security matters. It's going to be released very shortly if it hasn't already. And the data there are striking. And note, this is data collected before ISIL became a household name, before the most recent sort of spike in coverage and concern. But only 1 in 3 thinks that the restrictions on the National Security Agency should be increased. More people think it should remain the same, and there's a small number that think that there should be fewer restrictions. It's a plurality of the public thinks that the budget for general information gathering, so the NSA's budget and Matthew's salary, should remain the same that it is now. And 7 in 10, a supermajority, say that it's more important for the federal government to investigate possible terrorist threats, even if that intrudes on personal privacy. So they tilt the privacy security balance in the direction of security. They want to keep Gitmo than want to close it. Very little positive affect towards Snowden. So Bart Gellman may win a Pulitzer, but the general public doesn't view Snowden as a hero. Put another way, this is a public that the NSA could work with. I mean, this is more of an NSA kind of public, I think, than a Ron Paul public. There, of course, are very outspoken minority groups that hold to a Ron Paul view, but in general, the public, I think, is more sympathetic to what the NSA is doing. The second proposition is that the public is not panicky about terrorism, but nor is it sanguine about the terrorist threat. So the public is still quite worried. You know, this is now 13 years after 9/11, still worried about terrorism, and they're actually even more worried about terrorism than they've been in a decade. That is, the 2014 data is higher than a decade ago. 34% say terrorists have a greater ability today than terrorists had on 9/11. And a decade ago, you would have only had 24% who say that. And about a third of the public thinks that the president has made the country less safe in this area. And all of these data is before Attorney General Holder said that the ISIL terrorist group was more frightening than anything he had seen. And before Secretary Hagel, the Secretary of Defense, described the threat in apocalyptic terms. This is a public before the most recent ISIL revelations. Third, my third proposition is because of those first two propositions, the politics do not favor poo-pooing the threat. And I think the president erred when he dismissed ISIL as a JV threat. JV team and this is in his New Yorker article. And you can be sure that if ISIL ever does succeed in attacking the U.S. homeland, that the lead in the Washington Post is going to be ISIL, the terrorist group that President Obama dismissed as a JV team problem, struck the United States yesterday. The president, I think, understands that was a mistake. Certainly his communications team does. That's why they've gone to such extraordinary lengths to attack and deflect criticisms about how the president's choices in Syria have contributed to the rise of ISIL. The president goes to really remarkable lengths to attack people who say that, and that effort by him is going to get harder and harder to do because the more trenchant criticisms are now coming from members of his team or former members of his team. So Secretary of State Clinton, Deputy Secretary of State Steinberg, former Ambassador Ford, Undersecretary Michelle Flournoy, they've all registered very compelling and thoughtful critiques, and many more Democrats have spoken on a not-for-attribution basis with Martin's staff and in a more bitter way about the problem. So it's impossible to dismiss this criticism as partisan. And paradoxically, the president's, or the recent success in terms of rescuing the Yazidi refugees on the mountaintop, that's going to increase the intensity of the political vice in which the president, I think, will find himself. That is, if ISIL does successfully attack the U.S. homeland and the president has not previously authorized strikes against them in Syria and elsewhere, then the question will be, well, why didn't he use tools that were successful for him in Iraq to deal with the threat in ISIL when his own advisor said you're not going to be able to contain this threat indefinitely without confronting them in Syria? So the political vice will tighten. The fourth proposition flows directly from that. These numbers, the poll numbers I described, are likely to spike in favor of a more robust counterterrorism effort, and including a robust intelligence collection, rather than the otherwise. I don't think we're heading into a period where the public will be clamoring for even more restrictions on NSA. I think the global instability trend lines point in the other direction. And it's easier for me to imagine scenarios where the public concern about this will increase dramatically than it is for me to imagine scenarios where the public will become more sanguine. And that intensifies further the political pressure on the administration, particularly the pressure to be more expansive on intelligence collection. One of the reasons that the Bush administration in the fall of 2001 moved as quickly as they could, accelerating and actually throwing out existing war plans and creating a new war plan in order to attack al-Qaeda in Afghanistan on an accelerated basis. The administration was very concerned that al-Qaeda would go up 2-0 on the U.S., that they would get a second strike in before the U.S. had been able to avenge the first strike. And they were concerned that in such a climate, if al-Qaeda had gone up 2-0 on the U.S., that the pressure from the public for an unrestrained, for a overwhelming response, for using all elements of national power, including perhaps even weapons of mass destruction, the nuclear option, the pressure on the administration would have been even greater. So part of the reason for moving so quickly was to bring the political environment back into a line with a more coherent and more reasonable counterterrorism strategy. And ironically, this president, President Obama, has put even greater pressure on the intelligence community. Ben Rhodes, who's the president's chief spokesperson in the national security area, recently said, this was about a week ago, that at that time there was no need to attack ISIL in Syria. And the reason was that they didn't have clear indications and warning yet, this was a week ago, that ISIL was going to pose a direct imminent threat to the homeland. But Ben Rhodes insisted that if we did get that clear indications and warning, then of course the president would authorize a strike. What that does, though, is put a tremendous amount of pressure on your indications and warning capacity. That was a shot across the bow of the intelligence community. That quote saying that, because that was in political terms saying, we don't need to act now because the intelligence community has not told us that we need to act now. And so if we're wrong, if there's a strike, the intelligence community hasn't warned us adequately. It's setting the political predicate for a blame shift, which has tremendous pressure on the intelligence community to open the aperture and make sure that there is not a single possible threat that goes unnoticed. And so this leads me to my fifth and final proposition, that there is an interesting policymaker and academic gap in this area, in the study of this issue. Let's stipulate, just for the sake of argument, and we can argue whether it's true or not, but for the sake of this panel, let's stipulate that some level of homeland risk is irreducible, that even if Matt does all of the work and his team does all the work, that there's some irreducible threat that remains. I've heard many, many academics accept that premise and then say, well, then why are we doing so much to reduce it? If there's some irreducible risk, why are we going to such great lengths, including accepting trade-offs on security and privacy from NSA? Why are we doing so much to reduce it? The policymakers I've interacted with see it in the mirror image. They say the threat is at this irreducible level precisely because we're going to such extraordinary lengths to reduce it. And that's why we have to maintain these extraordinary lengths so that the threat remains at whatever is the irreducible level. So I close by saying I think the pressure on the president will increase in this area. And I call to your attention what the president said a day or two ago in a speech to veterans. He said that if ISIL killed Americans, he would avenge their deaths. And no one should doubt his willingness to do so. And I accept that at face value. I certainly don't doubt his determination. He's proven that he will use all elements of national power to avenge the deaths of Americans. And Americans do want the president to avenge those deaths. But they want even more for the president to take all reasonable measures to prevent those deaths. They're not just interested in avenging, they want prevention. So, go back to my political vice problem for the president. If the president does not take action against ISIL because he's waiting for clear indications and warning of a homeland attack, and if he doesn't get those clear indications and warning because of restrictions that have been placed on the NSA, then in that hypothetical, the blowback will be severe, and debates as to whether the FISA approval process is overly general, I don't think will have much resonance with the voters.
Well, thank you, panel. Very interesting. And we want to see if there are any questions we have for each other. We have until 12, and we want to have ample time for Q&A. But let me launch our discussion by asking a question building on what Peter just said. Given his assessment of the political vice, can we expect to see any kind of reform of NSA? And if so, what would it look like?
Well, I'll jump in. So I do think, look, the president made a very important speech earlier this year in which he outlined the challenges that we face in this area, much along the lines that we've all discussed. I mean, he identified, for example, his speech took us back to the American Revolution, through the Civil War, through World War II, talked about intelligence gathering, and the inherent difficulty that we have in trying to balance national security and privacy and civil liberties. And one of the points I wanted to make today that I think that's really crucial from my perspective, having worked on these issues for several years, including under the past administration, is that this discussion didn't just begin with the Post story or the Guardian story last year. This is an ongoing debate. It's an ongoing debate with lawyers and policymakers, members of Congress, the courts, and with the public. And we can talk about how much can be public and how much should be public. But this debate's been going on. And the president pointed out there have been some big changes, though, right? The changes in technology. Laura talked about the fact that after 9/11 we're talking about threats inside the United States, the fact that our biggest adversaries are no longer nation states but asymmetric actors, and those have put pressure on our system. And that led the president to announce a series of reforms in his speech earlier this year. So the quick answer then is yes, there will be changes. Yes, Congress has undertaken legislation right now. There were changes that we made on the executive branch side that didn't require legislative changes, including going to the FISA court for approval for every time we look at the data that's collected under 215. But notwithstanding Laura's points about the ways in which 215 is out of whack with FISA, illegal under the statute, and unconstitutional, the reality is, and you may not realize this, but it actually is legal, and it is constitutional, and it is consistent with FISA, because every judge who's looked at it, with the exception of one judge, but every FISA court judge who's looked at it has said so. And as long as I'm in this seat at the National Counterterrorism Center, as long as I'm part of the counterterrorism community trying to protect the country, we're going to take advantage of those laws and policies and rules that allow us to do these things. So this is maybe where Laura wants it to go, but it's not where it is now. So there will be changes. The president said we're going to end bulk collection. We've gone to Congress and we put forward and worked with Congress on legislation that will end bulk collection, but it will still maintain an operational capability that is similar, essentially, to what we have now.
And quickly, maybe yes or no, can you live with these changes?
So we're working through that now, but some of the legislation that the House passed and that the Senate's considering now, I think, is certainly within the range that will maintain that operational capability, so yes.
So I'd like to highlight a political and a constitutional reason why we absolutely have to have those reforms. So Marty referred to we the people and the need to know the importance of this. It's a problem when the law says you have to have reasonable grounds to believe that information is relevant to an authorized investigation, and it turns out that all telephone calls are relevant, right? It's a problem when the law says you may not knowingly collect entirely domestic conversations, and the NSA says we know we collect tens of thousands of entirely domestic conversations, but in any one instance evidence we might not know at that time, so we're still going to collect it, right? It's a problem when the law says you have to be able to obtain this via subpoena ducis tecum, and no court in any district in the United States would allow you to collect for 7 years all telephony metadata of the citizens living there, right? It's a problem for democratic governance when the law says one thing, and inside a super secret classified world that only a handful of people have access to, something very different is being done in the people's name. The second point, so on this line, disclosures damage intelligence collection. I entirely agree with Matt on this point, but so does the use of the law in a manner that looks so different from what it actually says on its face. That also creates great damage, and the damage done there is to democratic governance. On the constitutional point, something we haven't really touched on is 702. And what's being done under 702 is it's not just information to or from so Section 702 deals with non-U.S. persons located outside the United States, the collection of information on them. 703 deals with U.S. persons outside the United States and the domestic collection of their information. And 704 is U.S. persons outside the U.S. and the international collection of their information, and different standards apply to each category. So 702, you're collecting information on non-U.S. persons, and one of Congress's concerns was that this would be used for reverse targeting. So they would say, for instance, the concern is that the intelligence agencies would say, well, we're targeting foreigners, and we're going to collect all international communications, but we're actually not targeting Americans in the United States. So we're just going to target overseas and use it to reverse target individuals in the country. And so that's why they introduced these other provisions, 703 and 704, minimization procedures, other mechanisms to try to prevent this from happening. What is actually happening is this is being interpreted not just information or communications to or from targets overseas, non-U.S. persons, but information about selectors related to those targets overseas, which is a broader understanding. You could collect more information. So if I communicate with somebody and there is reference in the content of my communications to a selector, that information can be collected and mined for further information, even though I never communicate with the target itself. This is called to, from, or about interpretation, TFA. Right? Now, this TFA has allowed the government to collect a lot more information than it would otherwise be allowed to collect, and it is now allowed to query that database using U.S. person information. So names, affiliations, titles, it could be Council on Foreign Relations, and you query the data to see if anything comes up. You can actually query this database, which the FBI has commingled with traditional FISA, and there is no record being kept of this. Now, under the Fourth Amendment, the right of the people, it refers back to the people, which under Verdugo Urquidez is understood as the political entity of U.S. citizens, not non-U.S. citizens. So the right of the people to be secure in their persons, papers, and effects against unreasonable search and seizure shall not be violated, right? We have this right, and yet U.S. person identifiers are being used to query this database. Now, the Foreign Intelligence Surveillance Court offered reasons saying why there was not a warrant required for the collection of the information in the first place, and they were good reasons, that when the purpose of the surveillance is not garden variety law enforcement, when the government's interest is particularly intense, and there's a high degree of probability that if you were to require a warrant, it would hinder the government's ability to collect time-sensitive information and would hurt U.S. national security, you can collect the information. None of those conditions hold when the FBI then goes back to the database to see if there's any evidence of criminal activity linked to non-national security-related criminal cases. Similarly, in Bin Laden, the Southern District of New York said, look, it's hard to get warrants for foreign intelligence collection overseas. It's hard to predict the international impact of seeking a warrant. There's a problem of foreign intelligence officials being seen as complicit. There's a danger of notifying enemies by alerting foreign officials what the United States is up to overseas. But when we already have the information in our hands, it is hard to argue why you shouldn't be required to get a warrant to search the data for evidence of criminal behavior, especially when it's utterly unrelated to national security interests. So the Privacy and Civil Liberties Board recently came out with a report where they said the FBI frequently does this, and they don't keep a record of it. They don't go to a court first. There's no probable cause required, and this amounts to an end run around the Fourth Amendment. So we have to have reform of this system to bring it within our constitutional purview.
I want to just change course a bit and maybe address some of the things that Peter said, because I felt there was a bit of characterization of what we think at the Washington Post and how we are and all of that sort of stuff. So let me offer some, I hope, clarifying remarks. First of all, we never said that Snowden's a hero, by the way. What we suggested was that in these documents that he provided us and The Guardian, that there was information that the public had a right to know and that had important public policy implications, and that probably should lead to a debate such as the one that we're involved in here today. We never suggested that the public's not concerned about terrorism. We're concerned about terrorism. We cover it every single day. And by the way, we feel it very acutely. The individual who was recently beheaded by the Islamic State was a journalist, and there are other journalists who are being held by terrorists throughout the world. So we're not Pollyannish about that subject. We didn't say that a majority of Americans favor greater restrictions on the NSA. In fact, we conducted our own polls, which showed pretty much what was reflected in the polls that Peter cited. Nonetheless, to say that 1 in 3 say restrictions should be increased is a substantial portion of the population, and I don't think just because something doesn't constitute a majority is that their views should be entirely dismissed. We have said that, and do feel that this level of surveillance does raise important constitutional issues, as Laura's been talking about, and is potentially subject to abuse. There's, no question that we're in a period of terrorism threat, and there's no question that in a period like that, individuals are willing to give up their rights in favor of security. But that's a decision that the American public can make through debates such as this one. The American public can arrive at a policy that they think is appropriate. And I suppose if they choose in some manner to give up their rights, they can do so. Although we do have a constitution, and those things have to be contested and discussed in courts and in forums, in political forums and forums such as this one. I do agree with Laura that while perhaps disclosure of these documents has had an impact, and perhaps a very serious impact on the government's ability to conduct surveillance and intelligence that it feels is important in the fight against terrorism, non-disclosure of all of this, that the fact that all of this was largely secret from the American public does in fact do damage to our civil liberties and our ability to govern ourselves.
Peter, any response?
Well, I think you just misunderstood my point. I was not attributing those to the views of the editorial board of the Washington Post, distinguished as that is. But but you're right that there's been a marked change in the tone of coverage of these issues, even since the tragic beheading. That the reporters that I talked to, their approach on this issue is different this week than it was even 2-3 months ago, and certainly at the height of the Snowden revelations, when the outrage was mostly directed at the NSA, and I think that there's been sort of a return to the more balanced perspective that you just articulated. I think there has been since then. The public has voted on these issues. Voted to re-elect President Bush. It voted to elect the people who passed the Patriot Act. It voted to re-elect President Obama. And both President Obama and President Bush defended these kinds of actions. So now there's obviously a lot of reasons why the public votes for a president. But the public, the gist of the distillation of my argument is that the public outrage at the NSA probably hit a high watermark, is what I would say, has hit the high watermark at the height of the Snowden coverage, and that world events are likely to push the public away from that, further and further away from that, more likely to do in that direction than to push them more and more in the direction of, say, Lauren's camp. Now, doesn't speak to the policy wisdom of whether reforms can be made. They have been made, and there'll probably be more tweaking on the margins. And certainly, if there is a oomph or any new action, it will be much more tailored and restrictive than the original 2001 oomph. So there is not to say that the public will force the politicians to be unrestrained, but it is to say that I think the public is moving more in the direction of taking more risks to confront terrorism than it is accepting more risks from not confronting terrorism.
Well, this is a political science convention, and one of the teachings of law and politics is the relationship between law and politics. And judges will often decide cases somewhat differently based upon the circumstances. The famous line, Supreme Court follows the headlines. Overly simplistic, but not untrue either. And perhaps the press, to some extent, at least in terms of what it publishes. So there's a dialectical relationship between politics and the law. Now, the panel, Laura, would be the most uncomfortable with that proposition. Is that fair to say?
That the courts follow politics?
Yeah, or that politics influences what courts do.
Oh, that's
especially in this domain. It's always been a separate domain for law.
That's very difficult. Obviously, when you teach which I'm about to start on Wednesday, my course, constitutional law, you're aware of the political context in which decisions are made and of the general orientation of the justices, but also the effort to reconcile propositions before it with constitutional provisions.
Absolutely.
So.
Yeah. Any comments you want to make before we go to the audience?
Yes, I just would throw out, I think both an observation and then I may have a question for Marty that I wanted to be able to ask. But the observation is that, look, this is really important discussion, and Laura's points, where the law is heading, really interesting and important part of this debate. But I think it would be wrong, and it's really a myth that I think has been sort of widely shared, that or widely viewed, that NSA is sort of lawlessly making these arguments and just going forward on its own, implementing these programs. The fact is that on 215, for example, the FISA court, independent Article 3 judges, 37 times, I believe, have upheld 215, including since the revelation of these of the Snowden documents and the debate in the public. The federal judges who've looked at it, 3 out of 4 have upheld 215. On the 702 side, Congress passed 702, fully understanding, after a debate, how it would be implemented. And the judges that have looked at it, the one judge that has looked at it has upheld it as constitutional, as statute, within the statute. So it may be the case that someday the law review article that Laura's writing will make its way into a court or into Congress and change the law, but that day is not today. And so from my perspective, we have an obligation to execute the law in a way that that protects the country and takes full advantage of the laws and tools that are on the books. I just think it's a misimpression to say that these are just arguments NSA is making or just ways that NSA is implementing these laws, because there are lots of people at the Justice Department, within the executive branch, within the FISA court, the judicial branch, within Congress, looking at these programs, validating them, reauthorizing them, and determining that they are within the statute and within the Constitution. But I think it's a really important issue, and I'd like to be able to ask Marty, because I think the hardest part of this, and I think you made a very reasonable sort of opening comment about how, and I agree with you with the way the Washington Post approaches these issues. I have had interaction with Post reporters about classified information that they've heard. The challenge, I think, is that the initial, or at least one challenge is the initial story that the Washington Post broke, I think it was the initial story, said that NSA had directly tapped into the servers, the central servers of internet companies, 9 internet companies. This was based on the slides that Snowden had released. This turned out not to be true. This was the lead story. So a lot of people might rightly think then and even today that that was the case. In fact, what that PRISM program was talking about was Section 702 of FISA, which had been debated, authorized, and validated by the courts. It's just and I understand there's pressure on the press to publish when you have something like that based on what you know, and there may be timeliness pressures as well. But the problem is unringing that bell, because that turned out not to be true, and you all would be forgiven if you think that today it is true, that NSA has tapped directly into the servers of American internet companies. Not true. Just not true. But it was the lead paragraph of that initial story. and it's very hard to change that impression once it's out there. So I think there's real pressure, and I know that there's a back and forth, and maybe we've gotten better at it in sort of in working with the press. But the other problem is that not every press outlet is the Washington Post or the New York Times and is engaged in that type of discussion with the government in an effort to be responsible. So that's my sort of question.
Let me address that. First of all, we had discussions with the Director of National Intelligence and with the NSA before publishing that story. The second point is that was an actual NSA document that said that they could tap directly into it, so it was an actual accurate account of what the NSA was telling its own people in its own documents. In addition, the story did not stop there. It actually said that the NSA and that the government denied that it was doing that, and it quoted extensively from technology companies, Google and the like, saying that they were not aware of this. This did not happen. So it did not stop at just saying the government can just willy-nilly tap into these networks. It actually quoted from the government saying this was not the case. It quoted from the technology companies saying it was not the case. But it also quoted from the actual NSA document in which it said it was the case, and that this was what they were doing. As far as every media outlet not being the Washington Post, I appreciate whatever deference is there to the Washington Post. The reality is that Snowden could have done what was done in the case of WikiLeaks. He could have actually turned this over to WikiLeaks, and all of this information without any intermediary being involved. The intermediary being us and The Guardian and some other publications over time. He could have just posted it all, put it all out there for anyone to look at, any terrorist organization, any other country to take a look at and pour through and look at it to their heart's desire. For reasons that he has articulated, he gave it to us to exercise our judgment, and in exercising our judgment, we spent, as I think you know, an enormous amount of time with the government going over this information and actually withholding information that the government felt was far too sensitive. And we spend months on some of these stories. We have spent an enormous amount of time, an enormous amount of money. We've also taken enormous precautions with the security of the documents that we have. So I don't think that's an act of irresponsibility in any way. And I think that, certainly the government would argue that nothing should be out there, that the government should essentially know everything and the public should know almost nothing. And that's not a position.
That's not my position.
All right. Well, that is the position, I think, of some, and that's not a position that I feel is consistent with the very principle of self-governance.
Okay, I think we need to move toward the Q&A. Laura would like to make one quick final point, but then we'll do the Q&A. Please line up behind the microphone. If you just ask your question back there, they cannot pick it up on the media.
So just a comment, responding to Matt on the Foreign Intelligence Surveillance Court. This reliance on the Foreign Intelligence Surveillance Court concerns me, and the reason why, if we look just across the board, in the past 10 years, of 20 judges on the court, only 3 were Democratic appointees to the court itself. Of the judges on the Foreign Intelligence Court of Review, all of the judges on the courts of review that have issued these important decisions bringing down, for instance, the wall between criminal law and national security were Republican appointees. 2 of the judges on the 3 panel that brought down this wall had actually said FISA itself was unconstitutional in the first place, Judges Silberman and Judge Guy. The applications that come before the court, in the past decade, FISC has ruled in 18,473 applications. Only 8 have been denied in whole and only 3 in part out of 18,000 cases to come before the court. There is no advocate opposed to the government at the court. These are in-camera ex parte proceedings. So there is nobody to argue against the government for these orders that are put into place. There's no advocate, constitutional advocate, or advocate that may challenge this at the time the orders are being put forward. And you see the impact of this. The judges that have released opinions, one of the opinions, when it treats Smith v. Maryland, it spends a page and a half as summarily dismissive of any question of third-party third-party data with no treatment of advanced technologies, of U.S. v. Jones, of these other cases that have been handed down. Now, of course, we have Ganius, we have these other cases that we can look to, and none of this is being cited, but there is no contrary opinion being expressed to the court at the time. And I would add to this that they were not designed to be a court to create precedent, and certainly not a Fourth Amendment warrant exception, which is what has happened with regard to 702. So the Foreign Intelligence Surveillance Court of Review now finds that there's a warrant exception to foreign intelligence collection, which has never been recognized at a domestic level. And since 1978, FISA has controlled those collections. So when you have a secret court, which is heavily skewed towards one direction, at least in terms of the appointments, which tends to agree to all of the order requests that are put before it, and these are secret, to then look to that as precedent for a court that wasn't designed to have precedent with no contrary counsel to rely on this as a state of the constitutional provisions, I find concerning.
So you would support an advocate
Absolutely.
at the FISA court for
Yeah,
that?
absolutely.
The whole panel could be devoted to that one question alone.
Yeah.
Okay, let's go to the Q&A.
My name is Steve Schifrin. I'm from the Cornell Law School. I have a question about, I want to push back a little on the third-party doctrine argument. I think the statutory arguments you made were absolutely compelling. On third-party doctrine, you argue that it's qualitatively different. And the argument is that it's a greater invasion of privacy. And it strikes me, I'm opposed to third-party doctrine from the beginning. And third-party doctrine knew there was a violation of privacy, but said it's irrelevant. You can take people's trash, you can get their bank records, you can get their email, you can get the bank records, including credit cards and so forth. You can get their telephone records. We know that invades privacy, but it's not within the scope. It's not a search. There's no reasonable expectation of privacy. So if it's qualitatively different under third-party doctrine, it doesn't make a difference. The second point is, it's not clear to me that it is qualitatively different. If you give me a choice between having the government get my bank records, my phone records, searching my trash and so forth, versus their knowing who I called, there's a much deeper invasion of privacy. It's qualitatively different in the sense more people are involved, but in terms of the particular invasions of privacy, the third-party doctrine already was doing greater invasions of privacy than the metadata of the NSA. The final point I want to raise with respect to this is a question. The requirements for a subpoena are not constitutional. And I'm wondering if Verizon says you can't get this without a subpoena, what is the relationship between the requirement for a subpoena and probable cause? I ask that because I don't know.
Okay, so, and feel free to jump in.
Okay, let's try to be brief because there's a lot of
Right, okay,
people
all
in
right. Probable cause is not required for a subpoena. It's not. And I actually have a discussion in the paper, in the 215 paper, of the subpoena cases that are relevant to this. The ones that the longest period that the courts have agreed is 2 years focused on a particular individual doing money orders in Chicago. That's the longest period of time, and probable cause was not required in that particular instance. On this broader point, whether there is a distinction, a qualitative difference, we have information available to us that was not available then. So social network analysis. You know, when you put one tap on Michael Lee Smith's phone to see if he calls somebody who he's suspected of actually harassing, sexually harassing and robbing and so on. That is different from saying, let's look at the social network and who's related to whom in this network, who the important nodes are, what the eigenvector centrality is in this particular network, which ones levy the most power with regard to others in that network. That's the kind of information one can get. You can also get trunk identifier information. Before, when we had landlines, you couldn't tell where Michael Lee Smith went during the day. Now we have cell phones, and so the tracking technologies that allow us to attach attached to each cell phone tower as we move around can now pinpoint where we go. So it's different kinds of information that one can get through these same third-party records. So I would say that even the telephony records are different from before in terms of the privacy interests. And beyond this, the type of information that we now digitally house with third parties is qualitatively different. So on the iCloud, the amount of information we put up about our private lives, our personal correspondence, our private dealings with others, you know, the home, the concept of inside the curtilage of the home, the filing cabinet is sacrosanct and you need a warrant to go into that filing cabinet. Just because we keep the contents of that filing cabinet on our pocket, you know, this is what this recent case, the Riley case, was about, whether or not you have this privacy interest in a cell phone when the police arrest you, or whether they need a warrant. And the court said, no, you need a warrant. This is a new world we live in. Similarly, in the intelligence community, the idea that just because we give this information to Apple or to Google or to whoever it is and store it on the cloud, that there is not a search for the government to go into it and get it, and therefore they don't need a warrant. I think that doesn't understand the privacy interests that are now implicated by how technology has changed the context in which we live our daily lives.
So it's just really important to emphasize one point after Laura, which is that when the government seeks for intelligence or not for intelligence purposes, but for under FISA to obtain the contents of communications of U.S. persons, they have to get a warrant. So nothing that we're talking about undermines that basic proposition. The government's going to get the contents of that information. They must get a warrant.
Leslie Francis from the University of Utah. This is a question about the contemporary structure of data and analytic techniques. With syndromic surveillance in the area of health, you don't know what you're looking for until you see a pattern. You don't know whether there's something of significance or who might be the relevant entity. Now, I'm actually very interested in privacy, and the gravamen of this question is to ask you, are there any ways, given that feature of analytics, to try to craft reform so that when you can't identify the target in advance, so that we can figure out ways to think about relevance and the use of subpoena power and so on, given that fact about the power of data and analysis? Thanks.
Yeah, so my thought in response to that, this presents in national security as a haystack argument. This is Senator Whitehouse is big on the haystack. Well, you know, can't you just build the haystack to find the needle in national security? So don't we need all this information so that we can find the needle that we're looking for in the haystack? That is a general warrant. A general warrant is something that allows you to just collect a lot of information to try to find some sort of evidence of wrongdoing. And as a constitutional matter, I would say that that is barred as a criminal matter under U.S. law in the Fourth Amendment. There is no automation exception, moreover. So if the government were to put cameras, video cameras in all of our bathrooms, right, and to record us, and they would say, but we don't access it. We're only going to access it when we actually suspect that there's activity, and we're going to just look at general patterns of behavior outside of that. That would be a privacy violation. So the fact that you build this haystack using computers and assume that there's no human intervention, that also is not established as some exception to the Fourth Amendment. So while I understand your concerns in privacy with regard to health law, that you're looking for patterns, when it comes to criminal matters where you can imprison people or kill them, right, underneath our doctrine that we have, this is something very different, and that's where constitutional protections come into play.
I would just add, though, that this gets us to an aspect we haven't talked about yet, but I think will prove increasingly politically relevant, and that is, while it's a fact that the NSA is not targeting each of us individually in this room or on this panel, I'm pretty sure, we are in fact targeted by Google, by Facebook, by private companies who are actually doing precisely the things that you just described. They've assembled the haystack and they're looking for things, and if you have any doubts about this, check out the ads that pop up when you watch Pandora or whatever. And so, when you listen to Pandora, I should say, the internet companies do this. And I recognize that there's an important constitutional distinction between the government doing this and private companies doing it. And of course, we all clicked that we accept that the companies will do this, so that makes it legal. But from a political point of view, I think the public will get increasingly uncomfortable with that level of targeted surveillance, and that you may see pressures for reform coming in through that door, and then maybe eventually migrating over to the national security area.
Hi, my name is Jason Kyber. I'm at Ohio State University. It's been a great panel. Thank you all very much. So I'm an international relations guy, so that's underlies the thrust of my question. So it seems like the NCTC and the terrorist environment, or the terrorist information data environment, TIDE, is the primary repository for CT information. And we know that the NSA is one of the primary collectors of that information, and I assume feeds the NCTC that information. And we also know that the U.S. has information sharing agreements with other countries. And in fact, there's a foreign partner extract of the terrorist watch list. So it seems to me like there's an interesting international dimension here. Can you comment a bit on, I know you're going to be limited in what you can say, on how foreign partners are actually benefiting from NSA surveillance activity? And is the NCTC TIDE database becoming a global counterterrorism information clearinghouse?
So that is a pretty well-informed question. We know our business quite well at NCTC, where we have the responsibility under the statute that created us to maintain the government's consolidated database, unknown and suspected terrorists, called TIDE. We share that a subset of that classified database with the Terrorist Screening Center, which is then responsible for using it for various screening purposes, airports and the like. And then some of that information is shared under sharing agreements with other countries. I think the important point is that when it comes to U.S. person information that, for example, NSA collects, that they have a series of rules and laws and policies that limit what can be shared about U.S. persons and minimization procedures based on what they collect, so that at every step in the process, from the initial collection of that information to its use in classified databases, to its use for screening purposes, and finally potentially sharing it with other countries, there are a number of steps all designed to protect the privacy and civil liberties of U.S. persons that are taken along the way. So I think that's about the best way to answer it. It's probably a longer answer to get to the basis of your question, but again, there's a number of safeguards built into that system to protect privacy and civil liberties of U.S. persons.
Thank you. My name is Grant Haver. I'm from George Mason University, and I was wondering what reforms do you think we could do to optimize both the need for the people to provide oversight to the NSA, and also the NSA's need to protect ways and means?
Well, one that I didn't mention before, but we touched on, is that possible changes to the way the FISA court operates. And one of the suggestions there, one that in fact Judge Bates, who formerly the chief judge of the FISA court, wrote a letter recently that touched on this, addressed this issue, and advocating an amicus role, so a friend of the court role, in certain cases at the discretion of the court. That seems to me like a reasonable way to increase public confidence in the work of the court. Look, the work of the court is necessarily classified, much of it. It's not a secret court. We know the court exists. We know who's on it. But it does operate much of the time in a classified environment, because the information that's being presented itself is classified. But one way to build additional trust in the work of the court would be to have an amicus role, and I think that's one that I think makes some degree of sense.
So I agree, but there are many other possibilities for reform. So one of the problems on the court is they, for instance, don't have the technological expertise, and they don't have the resources to really monitor the things that they're asking the NSA and others to do. So for instance, for almost 3 years, the NSA was querying data without reasonable articulable suspicion, even though the court had required it. And when the new administration came in 2009, they realized what was happening. Within a week, reported it to the court, and that's actually one thing I do want to say, that although there's no contrary counsel, there's no advocate on the other side, NSD at DOJ has done an exemplary job and really takes their job very seriously in terms of trying to present contrary arguments. So the structure is not a denigration on the actual way in which it's been, people have tried to carry out their due diligence and their responsibilities. In this case, this is a great example of that. In 2009, NSD found out that the NSA had been querying the database without reasonable articulable suspicion, as the court had required, and immediately told the court. And then there's a whole backlog of, back and forth trying to sort that out. And the reason they didn't understand is because they were relying on the NSA to police itself. I don't think courts can or should do that. That's not their role to kick that to somebody else to say that, are you doing this appropriately? Nor should they really be in an oversight capacity, right? They should be a court. So they should have the technological expertise. There should be somebody with the technological expertise also to oversee what's actually being done at the NSA and other MCTs. That's another good example, the multi-communication transactions, and finding out that there were wholly domestic communications in there. I think a lot of this, the technology is very hard, and they need to have some help in that regard. And then there's one more point I do want to make, and that's Congress. I've been surprised by somewhat disingenuous response from certain congressional members, which is that of an ostrich, right? They say, oh, we didn't know that this was going on. The reason that's remarkable to me is I think the executive branch has made it clear. So you could argue that in 2008, Congress did not realize what they were authorizing with the FAA, with the FISA Amendments Act, with Section 702. You could make that argument based on congressional member statements. Many members of Congress actually got it wrong when they portrayed what they were doing. They said this doesn't allow programmatic collection. Those who did recognize programmatic collection objected on those grounds. So nobody supporting the legislation was saying this will be used for programmatic collection, and those who supported it said we can't actually do this for programmatic. That might be true in 2008. By 2012, there were enough times that the executive branch had gone to them and said, look, we're doing this, look, we're doing this. And the fact that congressional members say, oh, well, it's really hard to go to a SCIF, or I don't have enough staff to do it, or, that's abdicating a responsibility. So if you're going to renew legislation, you'd better know how that legislation is being used. And so I've been surprised by the extent to which certain congressional members have really abdicated that responsibility, which is so central in a liberal democratic state.
I just have to take issue with the idea that there was an abdication of responsibility on the part of Congress. I think in 2008 there was a full airing of what exactly was going to be implemented following, based on that legislation, and Congress understood it, passed the legislation, understood it in 2012. It wasn't a matter of whether they couldn't go to a SCIF or couldn't read it. They actually thought it was the right thing to do, and those who voted for it. I don't see that as an abdication of responsibility by Congress.
Well, thank you very much for coming, and I know that I am going to look at future events along these lines with a much more informed ear.
A reminder, you can see this discussion on NSA surveillance on our website, cspan.org. Elsewhere in Washington,